President Trump's decision to defy the House Judiciary Committee's subpoena for the unredacted Mueller report puts the administration and House Democrats on a collision course. Democrat Jerry Nadler chairs that committee and issued a stark warning this week that the country is in a constitutional crisis. Chairman Nadler joins us now from Capitol Hill. Chairman Nadler, thank you for being here. My question is, are we at an impasse? The president saying, I'm not going to go along with any subpoenas from Congress. You have the White House press secretary saying what you did and holding the attorney general in contempt is unlawful.
Well, we are in a constitutional crisis because of the administration's contempt for law, their refusal to obey the law, whether it's their refusal to hand over the president's tax returns to the chairman of Ways and Means when the law says they must do that, whether it's their family separation at the border, whether it's they're opposing the constitutionality of a duly passed act of Congress, the Affordable Care Act, in court, and now the president's obstructions of justice, as documented in the Mueller report, and now the president's decision. An announced decision that he's going to defy all subpoenas from the House.
Right.
That means he's denying the role of the House of Representatives as a coordinated branch of government, and he's trying to establish the presidency as a dictatorship. You cannot have a democratic government, which is supposed to be tripartite, that the legislative, the judiciary, and the presidency, if the executive denies all information, and denies all lawful subpoenas. It's just a complete defiance of law. And that's a crisis. And the other part of it is that they've turned the Justice Department, which is supposed to enforce the law, into an agency for defying the law as the personal property of the president against the laws of the United States. That is a crisis.
But Congressman, what recourse does Congress have realistically? I mean, if all this ends up in the courts, aren't you looking at weeks and months of wrangling in the court with no resolution here?
Well, we're certainly looking at weeks, maybe months in court, but we have no alternative because we have to vindicate the role of law, and we have to insist that no president is above the law, no American is above the law, no president is above the law, or a dictator. Presidents have to respect Congress as the representatives of the American people and have to be willing to give information requested by Congress on behalf of the American people. And simply to say you're not going to obey any subpoenas is flat-out defiance of law. Is going to be found wrong in court. The courts are not going to sustain that. There's no basis for it. But they're just trying. They're being totally lawless, and a lawless administration is a tyrannical administration.
But what does that mean, Congressman Nadler, in terms of what you can do? You're now holding. Your committee has voted to hold the Attorney General in contempt. My understanding is that citation expires at the end of this term of Congress. What recourse do others in Congress have to make the administration cooperate?
The only recourse we have is to cite the Attorney General, and I'm sure others. I'm sure that other committees will be citing other officials in the administration for contempt shortly. We'll pass those on the floor of the House, and we'll have to go to court.
But my question is, what does it lead to? And meanwhile, the American people...
What it leads to, hopefully, is a swift court order with compulsion behind it.
I'm sorry, could you repeat that again?
What it leads to, hopefully, are swift court orders saying you must supply this information or you must do this or that, as the case may be, with the court-ordered compulsion behind it. A court can fine an official $40 or $50 or $100,000 a day until he does what is necessary.
But our understanding is the law around so many of these issues is not black and white. It's not all entirely clear. That again, you're looking at wrangling.
I disagree. The law is quite clear on most of these issues. For example, any subpoena must be adhered to. The information must be supplied unless you have a legal reason not to do so. And presidential privilege, which they're claiming, has certain limits. And the Supreme Court 8-0 in the Nixon case said that even the most closely held privilege, where the president was talking to his own advisors, is not valid when you're talking about potential wrongdoing by the administration. Second of all, it is very clear, black letter law, that once you give any information to a third party, to the press, to somebody's lawyer, to the Mueller investigation. You've waived the privilege. And all the information we've demanded is of that character. So there's no question legally we'll win. The question is how long it'll take.
Congressman, very quickly, as you know, the administration is pointing out that something like 92% or more of the Mueller report has already been made public. So what more is it that you and others in Congress need to see?
The other 8%. And you can't judge the importance of information from percentages. And in every previous case, whether it was the Nixon case or the Iran-Contra case or the Clinton case or other cases, Congress, or at least the judiciary committees, have seen all the information and the underlying materials. We agree that some of that information cannot be made public, but that decision is for Congress, for the Judiciary Committee, not for the President and not for the Attorney General.
So finally, Congressman, it sounds like you're not backing down.
We cannot back down. To back down would be to admit that the administration may hold all material secret from Congress, and Congress might as well go home, and then you have the President as a dictator above the law. We cannot admit that. We rebelled against George III 250-odd years ago, and we cannot admit that it was all a waste of time.
Chairman Jerry Nadler of the Judiciary Committee, thank you.
You're welcome.